Hey, everybody. Hello, everybody. Welcome back. This will be a pretty short hearing, I believe, at this point now. The prosecution, or actually the plaintiff in this event, has argued their side. Wood and his defense team have put in all their rebuttals. The judge dismissed for a few minutes and, well, actually for the last hour. And I suspect his ruling is going to be really quick. So I think this will be really short. It was intended to start just a few minutes ago. So I'm suspecting at any moment it will. But I wanted to just pop in for a moment and say hi to everybody. So just looking in the list, thanks for jumping in. CJ Ballard, Amber Bowen, Wilma Smith, Cassidy St. George, Superior Lake Girl, or Lake Superior Girl. Thank you, Amber, Addie, Gary, Mimi J2. Thanks. I've been looking at some of the chats in there. Darcy Ann, thank you so much. That's very kind. Really appreciate that. Cassidy St. George. And let's see, Michelle Keith, thank you. Drowsy Doll 1964. Hello from Alaska. That's awesome. I love getting up to Alaska and fishing a little bit. Haven't made it for a long time. Lisa Wilson, thank you. I'll look for some questions, and if I can answer them, I will. I really appreciate, again, everyone for jumping on. And Cat's Eye, thanks for getting in. Angela Cumberbatch, thank you. This is going to be kind of interesting to see what happens. And again, I think procedurally, it will go really quick. I think the defense has made some really great arguments that people need to consider, and that has Woods gone too far in some of the questioning? And it's a really difficult thing when you're conducting an interview, and you've seen that even live as we've done some interviews with people, that you can allow your own emotion to get involved sometimes. Who wouldn't be a little bit emotional about this case if you were the prosecutor defending it? But there clearly are some things, because the greater weight in this, in my opinion, is that if any of these things were found by the court to be egregious, they could be things that could eventually overturn the trial and send it back to be retried later, which just would be a disaster. I mean, you'd be as frustrated as you are with, like, Scott Peterson, and watching pieces of that trial that have fallen apart. They've had to go back and do. So let's just kind of watch. We'll see what happens here. And I really appreciate the guys in the back office jumping on at this last minute to see what's going on. If there's some questions that come up that I can answer, I certainly will try to. But again, I mean, I'm not a lawyer. I can give you my impression after, having been chief of staff in an attorney general's office and having sat in a courtroom an awfully lot during my career. And what I'm seeing just is kind of normal. And like I said earlier on, as we started this discussion about this particular hearing, is oftentimes when you're a young rookie police officer, for instance, and a defense attorney really attacks you and the way you do things, you walk away with your pride stumped, and you're frustrated, and you're feeling picked on. But then you kind of learn over time that if they start picking on these kinds of things, that means that the rest of the evidence has a lot of weight behind it, and probably are areas that would be more difficult. So attack the credibility of the person. In effect, the old, I think it was Billy Joel that did "Don't Shoot the Piano Player." It's really kind of an interesting time. So we'll see what happens. I'll jump into the chat and just watch for a minute. We'll pull up the screen and wait for the judge to come back. And if I see something that pops up that you need to hear me yammering on, I'll jump back on. But I'll tell you, I just can't thank you enough for jumping on. Let's see. Question. Oh, by the way, thank you. That's JRS. Thank you. I am going to record the book, and we have been talking about the style that should be. We actually looked into getting an actor to do the reading, but so many of you have mentioned that you'd prefer that it was in my voice, and so beginning in the next couple of days, I'm going to start doing the recording. The publisher has promised us that the book will arrive on the 15th to the 19th because of the holiday. It could be somewhere in that spread, and they'll start shipping. And then probably in about 2 months, month and a half or so, we hope to have the audio version and the ebook version ready to deliver. So that's really nice. And to all of you, thank you. I mean, I know we've talked a lot about it. Part of that is my fault in trying to make sure that we sell the book. We've worked awfully hard on it. So it looks like they're up and ready to go. So let's jump in.
All right, Madam Clerk, are we ready?
Yes, Your Honor.
All right. Appreciate your patience. We're starting a little later than I indicated. We'll be back on the record. These are cases CR 22-2755 and CR 22-2838, State versus Chad Daybell and State versus Lori Vallow. The court took a recess after considering the closing arguments today, and I'm prepared to make a ruling on these motions. In this case, the defendants have each filed motions to disqualify the prosecuting attorney. The court has considered the pleadings, the evidence submitted in the hearing on January 6th, and the arguments that were submitted today. As a preliminary question, the court has to determine what is the appropriate standard of review for granting or denying these motions. Pardon me. As has been pointed out by both the experts and in argument, there really are no Idaho cases directly on point to identify what is the precise standard for this motion to disqualify a prosecutor pre-trial. And there's no Idaho precedent the court's aware of where this remedy has been ordered by a trial court in a pending case. Neither defendant provided any citation for an appropriate standard of review, but made argument in support of their belief of what the standard should be. The state has referred the court to a standard in the Weaver versus Millard case, which was set forth in the state's brief. That case is a civil case, and while it's instructive to the court, I do share a concern that was raised by Mr. Means in his rebuttal argument that the civil standard may not be appropriate for a criminal case, and that would be because of the heightened duties that a prosecutor is charged with and the additional constitutional protections that are afforded to criminal defendants versus a civil standard. And so in the court's opinion that the Weaver versus Millard may not be the correct standard and will not be used for determining these motions at this hearing. There is some Idaho case law out there that for good cause, a trial court can in its discretion appoint a substitute attorney for an indigent defendant, for example, and that would be State versus Lippert, 145 Idaho 586. However, that is for the constitutionally guaranteed right of representation of an indigent defendant and does not necessarily apply to a trial court having the ability to order a substitute attorney to represent the state. In looking at other jurisdictions then, the court has located a precedent out of New York that is persuasive and will be adopted in this case, as I think this is a novel issue in terms of precedent. The case I'm referring to is called State versus Paperno, a 1981 case out of New York, found at 54 New York 2nd 294. And that case deals directly with the issue of a defendant's pretrial motion to disqualify a prosecutor. The standard as stated in that case is as follows. It indicates first, the burden is on, well, let me read that directly from the case. The standard they use is that on a pretrial motion to disqualify the prosecutor, it is incumbent upon the defendant to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. A mere assertion by the defendant that he intends to question some aspect of the prosecutor's conduct is insufficient. Rather, the defendant must demonstrate that there is a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So according to that, the burden is on the defendants to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. And second, there must be a showing that there's a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So in reviewing then the motions with that standard, I look at the motions which mirror each other in their allegations. The allegations are, number one, that the prosecutor alleged misconduct violated due process rights of the defendants under the Idaho and U.S. Constitution, right to a fair and impartial trial, that the prosecutor engaged in coercive, unduly influential, and intimidating tactics to manipulate a material witness in this case. The second allegation in the motions is the prosecutor in this case violated the Idaho rules of professional conduct, as well as the ABA rules by his actions. The third allegation is the prosecutor's alleged misconduct could be construed under the witness tampering and witness intimidation statutes as criminal acts. Number four, the allegation that the prosecutor's alleged misconduct has made him a material witness in this criminal case. And number five, the prosecutor's alleged misconduct has caused the potential for future civil litigation directed at Fremont and Madison counties, as well as the prosecutor. And then number six, that the prosecutor's alleged misconduct has included concealing evidence in violation of Brady and Rule 16 of the Idaho Rules of Criminal Procedure. The court would note that in terms of the fourth allegation about the prosecutor being made a material witness in the case, there is some Idaho precedent on authority on when that occurs, and that would be the State versus Aguilar case. And that case is at 135 Idaho 894, and that states that the party seeking such testimony, meaning from a prosecutor, must demonstrate that the evidence is vital to his case and that his inability to present the same or similar facts from another source creates a compelling need for the testimony. Also, that a defendant has an obligation to exhaust other available sources of evidence before a court should sustain efforts to call a participating prosecutor as a witness, and that case states that such motions are generally disfavored. In determining then these allegations in the standard I've announced, then I've considered the evidence submitted, including the submitted pleadings and exhibit and the testimony of the three witnesses, including Garrett Smith, the attorney from Arizona, the expert witness opinions and testimony and reports of Dr. James Davidson and Dr. Samuel Newton. I've also considered, of course, the transcript of the audio recording, as well as listened to the recording of the potential witness in this case and her discussion she had with Mr. Wood, which was submitted in the evidence of this hearing. So getting down to these allegations, counsel's alleged that there may have been or was a violation of Idaho Code 18-2604, which is Idaho's witness tampering criminal statute. Of course, to make a showing or to sustain the burden of violation of that would require the highest burden of proof because it's a criminal statute, so that would have to be shown beyond a reasonable doubt. Regarding the allegations of the Idaho Rules of Professional Conduct, of which there have been many allegations made, including rules 3.3, 3.4, 3.7, 4.2, and 8.4 of the Rules of Professional Conduct. The court considers, as a fact finder in this proceeding, that the standard of review to determine if there's been any violation of the Idaho Rules of Professional Conduct would be clear and convincing evidence, and that would be found under Warner versus Stewart, 129 Idaho 588, and the matter of Daw, 128 Idaho 80. In regards to those alleged violations of the rules of professional conduct, the Idaho State Bar governs the licensing of attorneys in the state and also enforces the rules of professional conduct. There's an office of bar counsel that conducts those hearings, which are administrative hearings. The bar counsel has the responsibility of investigating, and I'll quote from a rule, all matters involving possible misconduct called to their attention, and that's Idaho Bar Commission Rule 504B2. The state, in its brief, pardon me, I think I misplaced that, cites to the case of Cosman versus Dinius, which is 165 Idaho 375, which states unequivocally that the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar. So in other words, there's a separate governing agency that would make a determination as to whether or not any sanction should be imposed for violation of the Idaho Rules of Professional Conduct. Now, I understand that as the sitting and presiding court in this case, if I were convinced that an acting prosecutor was engaged in conduct that would result in a fair trial, then I would have an inherent ability to grant this motion, even though as I have mentioned, I don't see any prior precedent, or I haven't ever heard of that happening. The Idaho Constitution under Article 5, Section 2 does grant the court with the inherent right to administer justice in a case. But again, the standard I'm looking at for the motion would be the standard out of the State versus Paperno, New York case, which is that the question of one, did the pretrial activity of Mr. Wood in this case render his participation in the trial unfair? And two, was there a significant possibility that this pretrial activity will be a material issue in the case? In this case, then, we're dealing with the comments that were made to a potential material witness, who is the sister of the defendant, Lori Vallow. And as Mr. Evans pointed out during cross-examination, this witness may or may not ever be called to testify at a trial. So that's something I have to consider. The prosecutor, based on these allegations, could of course choose to recuse himself, but there's been no indication that he is doing that. Mr. Woods could, as if the allegations were true, be charged under that statute of Idaho Code 182604. There's no evidence or indication that that has happened. There could be a sanction issued by the Idaho State Bar, and their sanctions may include a private reprimand, a public reprimand, a suspension of license, or disbarment. Those are possibilities out there. There is no evidence before the court that the bar has taken any such action. So without knowing whether or not this potential witness will ever be called to testify at a trial, the court cannot find at this time that the interaction between Mr. Wood and the witness would render Mr. Wood's continued participation in this case unfair, and cannot determine that the prosecutor's pretrial activity will be a material issue in this case. For those reasons, then, the motions to disqualify Mr. Wood are denied. Now, if Ms. Shiflett in the future is called to testify at trial in this case, the court would require a pretrial hearing based on the evidence I heard at this hearing, which has been referred to as a taint hearing, and that was done in the case of State versus Severson, 147 Idaho 694. It's discussed in Head Note 46. So I would require that type of hearing before her testimony based on the evidence been presented by the defendants in this case. The court at this time has no other information of any other such conversations that may have occurred with other potential witnesses. If they did occur, then there may be a possibility of a future request for additional taint hearings for those witnesses as well. But that's not an issue before the court, as the only information submitted was the transcript and recording of the conversation with Ms. Shiflett. So finally, there were some concerning things in the recording in regards to the derogatory comments made by Mr. Wood about Mr. Means. I'm not going to issue an order to apologize or anything to that effect, but it's certainly my practice to always encourage a civility amongst counsel in my cases, and I'll just leave it up to Mr. Wood to determine whether or not he thinks that is an appropriate thing to do in order for continued civility and professionalism going forward in this case. Finally, of course, if the Idaho State Bar were to take any action, this court would be advised of that by the State Bar Association, and this issue may be subject to being reopened for further findings and conclusions if I received any such information. But any decision regarding a sanction for any violation of the ethical rules, if they did occur, is left to the sound determination and discretion of the Idaho State Bar. So that will be the court's ruling on these motions. Mr. Evans, I would ask that you prepare an order indicating that the motions are denied, and also include in the order the indication that the court would require a pretrial hearing to have an in-camera interview of Ms. Shiflett before trial, or well, don't necessarily be an in-camera interview, just say that a hearing, pretrial hearing would be required if she is in fact to testify at trial.
Very good, Your Honor. Thank you.
All right. Mr. Pryor, do you have any questions on the court's ruling?
No, Judge.
Thank you. Mr. Means, any questions on my ruling today?
No, Your Honor. Thank you for your efforts.
Thank you. And Mr. Evans, does the state have any questions on my ruling?
No, Your Honor. Thank you.
All right. Counsel, we do have some other hearings we need to get scheduled, including, I guess, hearing on a motion to compel, change venue, and motions to dismiss. My preference, given the time, and I'd like to just arrange a conference call with counsel to look at calendaring and get these matters set. So I'll be available in the coming week. I'll reach out to counsel and let's look at our calendars and see when we want to get these additional motions scheduled. All right. Anything else we need to bring up on the case this afternoon then?
No, Your Honor. Thank you.
No, Your Honor.
All right. Thanks, everyone. And thank you to the Idaho Supreme Court for their support, as well as Fremont County. We'll be in recess.
Holy cow, if you could have heard that amazing rendition that I just gave. So I'm going to go back and start over. I'm so sorry, folks. Karen Sue, you asked about, wasn't it against the code of ethics? No. The sharing of information is really important, and we see that happen in a lot of different ways. What would have been unethical is if the evidence had been locked down by the court and someone shared it. But you know, if you think about this realistically, and we kind of push the emotion aside, it's really important that this hearing happened, that because the defense clearly would have claimed prosecutor bias. They clearly would have claimed that Summer would be coached if she did come in and testify, and all of those allegations could potentially lead to the case being overturned and returned back to the court. So it really is important that this happened today, even as frustrating as it was. And maybe it's a good learning lesson too for Prosecutor Wood, because it's kind of difficult when you do these investigations and these interviews to not let your personal opinions and biases slip in, and you got to constantly be on the guard that you are not doing something that someone could come back and hit you with. So hopefully that was helpful. And I don't know if there are any other questions from the back office that I should have answered, and we can go after them. You can read about this, I'm sure, in the paper or in all kinds of channels once this is done. But maybe we can just bounce through a couple of questions here. Are we going to do a show on the police officer who died at the Capitol? No, I don't think that we'll focus so much on one individual shooting. I mean, we've already had a lot of police officers already in the new year lose their lives. That was such a tragedy. I actually have a video that will be coming out later tonight where I'm talking a little bit about is defunding working, and could it be equated to some of the challenges that were faced at the Capitol in that terrorist event that happened at the Capitol a couple of days. We cannot stop focusing on whether these issues are race issues, whether they're frustration amid COVID, whether they, in this particular case, were politically motivated one way or the other. I'll kind of talk about a few of those things, but for me, the thing that I just want to continue to remind is that 2021 should be a year that we figure out how to be a little nicer to each other. I know that even in this platform and social world of YouTube and other things, people really want to get fights started. They want to get people angry. And, I'm just not interested in that. I think 2021 is a year in which we just try to be a little kinder to each other, and we try to be a whole lot more inclusive than perhaps we've been in the past. So hopefully that answers that. And I hope that you like that little public record clip that will come out later tonight. So I'm not going to take your whole nights away. It's just so nice to see you all on there. We have 600 people that jumped on. If there are any questions that you have, again, I'll watch the chat for a moment, and we'll see if there's something that I can answer. And please, if you haven't subscribed to the channel, please do. I really would appreciate it. I mean, it's nice for me. It's validating, obviously. I can't believe we're almost at 50,000 subscribers. I'd love to hit that. I will tell you that I'm really excited about Monday night. I think you're not going to want to miss choir practice on Monday night, and I'm going to have a police officer that I used to work with. He is actually the police officer that wrote the book, The Black Klansman. If you haven't watched the movie, it's an R-rated movie and it's pretty rough. So I watch it on VidAngel because I'm getting so sensitive anymore. But watch the Black Klansman. We'll have Ron Stallworth. This is the black police officer who infiltrated the Ku Klux Klan, and literally still to this day carries his membership card in the Ku Klux Klan because he convinced David Duke that he was someone that he needed in the Klan. Duke had no idea that he was black or that he was a police officer. I invited an assistant police chief. She is an amazing human being that I had the chance to work with for nearly 30 years. And she's going to join in and be my guest co-host for that. She also worked narcotics with Sergeant Stallworth, who will be with us. And so that'll be kind of fun for you to listen in on that. I think you're going to really enjoy it. Let's see. One of the questions is, would you ever have the chief from Detroit PD on? Well, actually, Darcy Ann, believe it or not, I know James Craig. In fact, the last time I saw him, we were having breakfast in Washington, D.C. He is an amazing man. Getting the major city chiefs, I've had the privilege over the last probably 15 years to attend the major cities' chiefs of police meetings and become friends with the major city chiefs in all of North America. I count him among my friends. Jimmy Craig is an amazing human being. He has done an incredible job running that department. But getting those guys on is so difficult. Their lives are so busy. So I hope that's an answer to you about that. But yes, I know Chief Craig very well, and that's really nice. My question about President Trump using social media during his term. Well, we try to stay completely away from politics on the channel. But one thing I will say is I really found it interesting. I was still working a lot of things in Washington, D.C. at the time that President Obama became president. In fact, I'm looking to see if I... This is kind of goofy. You probably don't want to see stuff like this. But this is the badge that I was given. Let's see if I can hold it up so the light can see it and you can see it. This is the badge I was given at the inauguration of President Obama on his second inauguration. The police chief, Kathy Lanier, in the Washington, D.C. Metropolitan Police Department is, again, a really dear friend, and I was invited over. But one thing that I thought was so interesting about Obama in comparison to President Trump was that President Obama, when he went into office, this is something that was relayed to me by one of the Secret Service agents, was that he was a tweeter too, but that his staff gathered around and said, President, you're now the president of the United States. You can't just go out and be tweeting like crazy. Let's get this into the control of others and make sure that it's representative of the office. I wonder if President Trump had taken a similar tact, if a lot of things that were just so disruptive and divisive may have never made it out. I don't know, but that's just my opinion. And please, again, let's not talk politics other than to say, aren't there some amazing lessons that we can learn as we go through time? Well, let me look at a couple more of these questions. There's a question about am I going to look into the 2 little boys missing in California City? I actually have been looking at that case, and I've been really troubled by a couple of things, and I very well may. I watched a number of interviews by the police chief, who I think has a tremendous presence with the public. I was just really impressed, and so yeah, I don't know how to answer that other than I might look into that case and offer, at least in one of the public record messages, some thoughts that I had on the behaviors that I'm witnessing there as I look at things. I think that will be an interesting one. Let's see. I saw a note from somebody there. Well, I don't know. You folks are amazing. This is another thing that I'd love your opinion on, that I hope to start doing more now that we're making a little bit of an adjustment, as you know, from the first of the year, with Chris moving over and doing his own thing, and me getting back to what I started with Profiling Evil. I hope to be able to spend more time just chatting with you like we're doing now, and would really appreciate any insight or feelings that you have about that. It would be helpful for me to know how to best kind of socialize with you and talk through things. So let's see. There's a question from Becky Patton that says, police were completely outnumbered and overwhelmed. What type of training do they get? They get extensive training. I think the thing that's going to become interesting, we've now seen the police chief step down of the Capitol Police Department. We've seen the sergeant of arms step down. We've seen an interesting thing. And again, please listen to my public record that's going to come out tonight or tomorrow morning, where I talk about this idea of defunding and the de-escalation challenge that we're facing, because it seems like we just swing on this wild pendulum, and we go from where we were to police officers now that I speak to in major cities and, quite frankly, at local jurisdictions are really concerned about whether their government agencies, including their leadership, will protect them if they try to do their job. And so we're seeing a lessening of things there. But it will be interesting to see how that shakes out and see how much of that defunding has to do with that. Well, gosh, folks, we've taken quite a bit of time. I just want to say thanks. Let's call it a night. I'll see you Monday night at choir practice, and thanks for all that you do for Profiling Evil.
Am I yelling at